Welcome to another installment of A Prosecutor's Perspective. My name is John Fleming and I'm a prosecutor in the Nacogdoches County Attorney's Office. This program is intended to provide information to the public about the duties and responsibilities of the County Attorney's Office, including general discussions of laws that the office is duty-bound to prosecute. We hope through this effort that the viewing public will learn more about its prosecuting attorneys, what they think, what they do, and we hope that this program will enhance the public's understanding of the role of a prosecutor in local law enforcement. This public venue allows for more detailed discussions of what happens in our office. There are fewer limits on time and space in this venue. It allows for more detailed conversations and hopefully a more complete understanding of the nature of prosecution. It is our hope that we can introduce various partners in the community who work closely with prosecutors, whether it be peace officers, probation officers, advocates who assist victims of crime, or mental health providers. We hope we can be a voice to help educate the public on the role of a prosecutor. None of the opinions expressed on this show are intended to be or replace legal advice. You should consult an attorney of your choosing if you have or think you have a legal problem.
Hello, my name is Stephanie Stevens and I'm a prosecutor at the Nacogdoches County Attorney's Office. With me here today is John Fleming, another prosecutor with the County Attorney's Office, and we'd like to talk to you today about something that we hope is very interesting to everybody, about different sentencing options and plea negotiations, which is a topic, John, that comes up constantly in our line of work, correct?
Absolutely, Stephanie, and I think a lot of people read our local paper, and over the years I've been asked many times, why did this person get probation? Why did this person get jail time? Why did this case get dismissed? And so what's not in the news frequently is how prosecutors arrive at making recommendations on particular cases. And so I hope through today's discussion that we can shed some light, I think, on that very important topic, hopefully provide some needed information to the public about the role of a prosecutor in connection with making recommendations of either probation or jail time or even some of the other options that we'll discuss more completely. I've always thought, Stephanie, with a discussion like this, it naturally dovetails with a phrase that we've come to know and hear a lot about in the news, and that is plea bargaining or plea negotiations. And so naturally this discussion today will touch upon that subject probably significantly.
Sure, because when we talk about, as prosecutors, recommending punishment and coming to an agreement about punishment, we're talking about a situation where a person has admitted their guilt. We're not talking about situations where people have had a jury, contested their guilt and had a trial, but in situations where people say, okay, I'm willing to plead guilty to this offense. What can we agree on as far as punishment goes?
Absolutely. And those are some of the kinds of things that we'll discuss today. But any kind of discussion along these lines should begin, I think, with an understanding of what probation means. And Stephanie, you've been a prosecutor for well over 20 years. Can you just describe what is probation?
Sure. We talk about two types of probation primarily, straight probation and deferred adjudication probation. Straight probation means that a person has been sentenced to some period of time in jail, if we're talking about a misdemeanor, or in the penitentiary or state jail, if we're talking about a felony, and the judge has said, instead of actually serving that time, I'm going to probate it. I'm going to put you on probation for a period of time, and you're going to have some conditions that you have to live by. You're going to be monitored by the probation department, have a probation officer. If you do all the things you're assigned to do, then when you successfully complete your probation, you'll never have to go to jail or to the penitentiary.
And that is, what you're talking about is what we sometimes call a straight probation.
Exactly.
And someone who has pled guilty to an offense and a judge agrees with the state's recommendation and probably with what the defense attorney has agreed upon as well through their client to a probation, that conviction stays on the record
Yes.
of the individual. Is that correct?
That's correct. It's a conviction for all purposes. There's some nuances in the law where we talk about probated convictions versus final convictions, but that person has actually been convicted of that offense. A judge has said, I find you guilty of this offense. And that's different from deferred adjudication, which is another type of probation. With deferred adjudication, a person pleads guilty, but the judge doesn't find them guilty. He makes a finding that he has sufficient evidence to find someone guilty, but he withholds a finding of guilt until they complete this probation. If they successfully complete the probation, which may be very similar, if not the same, to a straight probation, but if they complete that probation successfully, they are never convicted of that offense. And that can be a huge benefit. First of all, if somebody applies for a job and on the employment application it says, have you ever been convicted of a crime? They can honestly say, no, I have not. They may have spent 10 years on felony deferred adjudication, but they have not been convicted of a crime. So that's a huge benefit. That's the benefit to the offender, to the defendant. The benefit to the state is that a person who violates a deferred adjudication probation is still looking at the full range of punishment. Now, that's not as important to us in misdemeanors, where we're talking about a maximum jail time of a year. But where a person might be placed on 5 or 10 years deferred adjudication for a first-degree felony, that means if they violate their probation, the judge has the entire range of punishment, which goes up to life in the penitentiary, to assess against that person. So that's a huge stick, but they've got the carrot of not having that conviction if they do it right.
And so clearly, Stephanie, there's an advantage depending upon where you're looking to pleading to securing a deferred adjudication probation versus a straight probation.
Absolutely, absolutely. And on the other hand, there's an advantage to a defendant on a straight probation, because in that situation, your time is limited. A sentence can only be probated if the original sentence is 10 years or less. So if a person gets a 9-year sentence and it's probated for 5 years or 10 years, however long, and they violate that probation, the worst thing the judge can do to them is that 9-year original sentence, even if it was a first-degree felony. So that might be a benefit to a defendant who has some question about whether or not they're going to be comfortable and successful on probation. Although ideally, somebody who has doubts about whether or not they can be successful probably isn't a good candidate for probation to begin with.
Which is another interesting subject for us to discuss at some point in time, and we may even get to it today
Sure.
later. But in terms of options that are available to prosecutors, certainly probation we've talked
Yes.
about, but jail time.
Yes.
Can you speak to that? Jail time is an option, and sometimes we'll hear about prison time. What's really the difference there?
Jail goes to misdemeanors, prison goes to felonies, is the short answer. In Texas, we have 3 types of misdemeanors, Class A, B, and C misdemeanors. C misdemeanors are fine only, like traffic tickets and that sort of thing. Class B misdemeanors have a range of punishment of up to 180 days in jail and or a fine of up to $2,000. Then Class A misdemeanors have a range of punishment of up to a year in the county jail and or a $4,000 fine. The important thing is that those are jails, which are our local incarceration facilities, our local correctional facilities that are being paid for by the county, not by the state.
So, for instance, in misdemeanor cases, if someone were reading that an individual received a 90-day sentence at the misdemeanor level, that individual would be serving their time in our county jail.
Yes.
Here in Nacogdoches County.
Absolutely.
Is that correct? Okay.
Yes. And then when we talk about felonies, we've got 4 different types, really it's 5 different types of felonies. We've got state jail felonies, we've got 3rd degree, 2nd degree, 1st degree felonies, and then capital felonies. A state jail felony is punishable by 180 days to 2 years in a state jail facility, which is it's a facility that is run by the state. Originally, state jails were designed to be much more rehabilitative, to house people who are pretty much nonviolent offenders, property crimes, lower-level drug cases. And the legislature's original intent was to have rehabilitative programs within the state jail. Well, those have never been fully funded, and we've had state jails felonies since I think 1994, so we're still waiting on those programs to be funded. Then with third-degree, second-degree, and first-degree felonies, the range of punishment includes time in the penitentiary in the Texas Department of Criminal Justice Institutional Division, which is the penitentiary that's being run by the state, not by the counties.
So someone who's convicted of a state jail felony, they would be going to a state jail facility.
Yes, and the state jail facility is part of the Texas Department of Criminal Justice. The other idea behind the state jails is that they're more community located. Someone who's convicted of a felony here in Nacogdoches County and sentenced to 15 years in the penitentiary, they could go anywhere. It's wherever they have a bed for them. It might be out in El Paso or up in the Panhandle. With state jails, the idea was to keep the person relatively close to their home community. We don't have a state jail here within our county, but we certainly have state jails in the East Texas area.
Now, I know we've been talking about sentencing, Stephanie, and we're making some assumptions here. The prosecutor makes a recommendation to the judge. Frequently, we have a defense attorney who has joined in that recommendation based upon an agreement, for instance, from their client. But this agreement is presented to a judge, and a judge does not have to accept that agreement. Is that correct?
That's right. And if a judge doesn't accept the agreement, a defendant is free to withdraw their plea of guilty and go forward with the trial and require the state to prove their guilt beyond a reasonable doubt. So there's a escape mechanism for a defendant if a judge decides he doesn't want to honor a plea agreement.
And what might be some reasons a judge would feel uncomfortable honoring an agreement?
There aren't a whole lot. Well, I can think of some misdemeanor examples. For example, there might be a DWI defendant who has prior DWIs, and we can talk more about this sort of thing, but because of information that the state knows, we're offering this person another probation with some certain conditions, because remember, probation is supposed to be rehabilitative also. But the judge may be uncomfortable about putting somebody with a long criminal history on probation, or a judge may see something in a defendant where he's not comfortable sentencing this particular person to a long period of time in jail for this particular offense. And he may say, well, you know what, I'm seeing something here that I can work with.
Absolutely. And when a prosecutor and a defense attorney are working toward a resolution of a case, assuming that that's something that can happen, should they be taking into consideration what the judge may or may not accept?
Sure, absolutely. It's not a matrix. It's not like you can say, all right, I have this crime and I have this defendant, so that means my recommendation should be here. There are so many factors to look at, and each case is individual. Each crime is individual. Each defendant is individual. We try to be the voice of the community to an extent. We want to be making recommendations in line with what our community expects.
Right, and I think that when we're talking about plea negotiations, at least there's many factors I think that go into recommendations that I make as a prosecutor to a judge, but certainly the community standard is significant. And how, for example, a possession of marijuana case would be resolved in Nacogdoches County may very well be different than it would be resolved in Travis County.
Oh, absolutely.
And that's something that a prosecutor should be taking into consideration.
And that kind of ties in with what what we think a judge will or will not approve, because the judge is also the person who sees what juries do. He's there every day that we're in trial, and he sees how juries react to different types of evidence. So he kind of has a good idea. Now, I'm not saying there's not the occasional case where a prosecutor has to kind of throw down the gauntlet and say, Judge, if that's what you want to do, you're the judge, but that's not what I'm going to recommend in this case.
Right. And Stephanie, when in terms of plea negotiations, which is something that we engage in every day, sometimes I think that there is the sentiment that plea negotiations are a bad thing. Can you share your thoughts on, is it a good thing? Is it a bad thing?
It's an incredibly wonderful thing, John. We have one county court at law judge, and last year our office prosecuted, or we filed over 4,000 misdemeanor cases. There are 365 days in a year, and it's going to take us at least a day and a half probably to try every single case. So if we went to trial every day, we could never try 4,000 cases in a year.
Which is part of the reason why there are plea negotiations.
Absolutely.
Now, in terms of specific, but having said that, I think that at least in our office, one of the things we want to do is look at every case as closely as we can. And because we have 4 prosecutors in the office, that allows us some liberties that maybe some other offices don't have. But in terms of making a recommendation, probably one of the most important factors that I consider is the age of the defendant. Is this a young defendant? And then right behind that is their criminal history. Is this a person who has been in trouble with the law before, or is this a person who's a first-time offender? And that can very much impact things. If, for instance, we have someone who doesn't have any prior law enforcement contact, that person may be a candidate for probation, maybe even deferred adjudication probation. If, on the other hand, I look at that individual's criminal history and I see that they've had law enforcement contact recently, maybe one time, maybe 2 times, maybe thefts, maybe criminal mischiefs, I start to think this person doesn't need a second chance. I'm starting to think more along the lines of a jail time component to my recommendation. Probably because they've already been on probation and probation didn't work. It didn't rehabilitate. We had hoped that probation would work, but then it didn't. So I think that the age of the defendant becomes significant, the criminal history, and then obviously if we have a victim, if we have a specific victim, and I don't believe in this idea, personally, Stephanie, that we have victimless crimes. We've talked about that before. Some people believe that DWI is a victimless crime. I believe that the public is a victim of DWI. There can also be individual victims. But if we have a particular individual who has been the victim of assault family violence, we want input from that victim. And in fact, we're required now by law to reach out to our victims for input in connection with plea bargains.
Absolutely. We have a victims assistance coordinator in our office, Nathan Collier, and Nathan's job is to reach out to victims to make sure they understand the resources that are available to them, because our criminal justice system has 3 goals. Punishment in our system has 3 goals: to punish, to deter, and to rehabilitate. But I like to think there's almost a 4th goal in there. We've got to try to make people who are victims of crimes as whole as we can. We're never going to be able to fix what happened. We're never going to be able to take away the experience. But at least we can make this person understand that we do consider what they have to say. And I always say to victims, I may not do exactly what you ask me to do, but it's very important to me to know how you feel. What do you think we should do here? This person's sentence could be probated, and we could send them to anger management. They could pay you restitution. They could perform community service, or they could go to jail too. And maybe restitution isn't important to you. So, like I said, I'm not always going to do what a victim wants me to do, but I think it's somewhat empowering and important to the victim to have some input into what's happening.
And a lot of people don't realize that there's actually a victim's Bill of Rights in the state of Texas, that victims of crime have a long laundry list, so to speak, of rights: a right to be made aware of court dates, a right to be made aware of when a perpetrator of a crime against them is being released from jail, for instance. So obviously victim input is important. I also like to know what law enforcement is thinking. I'm interested in visiting with the law enforcement officers who made the arrest, particularly if we have a defendant who was uncooperative, who was very difficult. Those kinds of things. What are some other factors, Stephanie, that you look for in connection with making recommendations for resolutions of cases?
You know, I look at criminal history, I look at age, but I look at more than just age of a defendant. I want to know something about this person. Is this a high school student? Are they going to school? What grades do they make? I have friends who work at the high school in the administration, and I often ask defendants, well, if I called Mr. So-and-so or Miss So-and-so, first of all, are they going to know your name? And secondly, what are they going to say about you? Because I want to know. And when we deal with misdemeanors, we're kind of in a unique position because we actually interact ourselves with some defendants, which doesn't happen with a felony. So you do get a feel for this person. Is this person showing any remorse for what happened? Does this person have any desire to be rehabilitated? Is this somebody that needs to go spend a few weeks in jail to get their attention?
Absolutely. And we can sometimes blend recommendations. It doesn't just have to be a jail sentence. It doesn't just have to be probation. We can make jail time as a condition of probation. And when we talk about community service hours, and sometimes there's this knee-jerk reaction, we put 40 hours of community service on an offer, and that will come out in the news media. But those community service hours are real commitments of time when that individual is away from family, and that has a punitive effect, or at least that's the idea.
It has a punitive effect, and community services, we've talked about this a lot, is extremely important to me because I think that people owe something to their community, and I like to think that in addition to, I guess in a way, punishing somebody by taking them away from their family and making them do some work, that maybe I'm fostering a sense of volunteerism with this person. Maybe I'm thinking that in vain, but it makes me feel a little bit better. I think that community service is an extremely important part of probation, and a lot of times defense attorneys will say, well, can we do something instead of community service? And my answer is always no, not unless, you know, if you've got somebody who can produce a doctor's note showing they are disabled in some way, then I'll entertain letting them do something else. But even then, I think, well, certainly we can find a job for them where they can sit at a desk or something.
Right. But I would at least, with respect to plea negotiations or plea bargaining, close that subject out to some degree by saying that I think that it's a fluid approach that prosecutors must take to every circumstance, and that when we first read an offense report that comes into our office and it appears to be an innocuous matter, or it appears to be a very egregious matter, we may acquire information 2 or 3 months down the road that changes our opinion. We may start to think, no, this individual needs jail time. This individual actually deserves probation. For whatever reasons. Has that been your experience as well?
John, I wish I had $1 for every time I've looked at a case for the first time and written on the front of the file, please don't ever, ever, ever give this person probation, only to come back myself later and put a big X through it and recommend probation to somebody. There have also been times where I sit down and I think, well, this is a probation case, and I learn something more about it. Or sometimes it's even just talking to a defendant when I go, this one isn't going to work. This just isn't going to work. Or maybe it's more appropriate that we give somebody probation with some jail time as a condition. Or maybe the more I look at this case and the more I learn about this case, this is a good time for somebody to do 180 days in jail.
Absolutely. And one of the things that we've not really touched upon, but we've alluded to it, is a concept known as prosecutorial discretion, where prosecutors are cloaked with a tremendous amount of discretion, both in terms of charging decisions that are made, as well as recommendations and how cases are resolved. It struck me when I first became a prosecutor, Stephanie, how much responsibility is placed into the hands of prosecutors all across the state of Texas. And we certainly want that authority wielded in a very responsible fashion. But can you share your thoughts on what prosecutorial discretion is?
Well, John, we have a lot of decisions to make. When the police refer a case to us, we first have to decide what charges we're going to file. And there may be a circumstance where we see a more serious crime than what the police sent over. There may be a situation to where we look at it and we say, you know, the more I hear about this, I really think a lesser crime is more appropriate in this circumstance. That's the first place we use our discretion. But certainly when it comes to making sentencing recommendations or plea bargaining and agreements, we use our discretion nonstop. And it comes back to, like we've been saying, there is no situation that's not a unique situation. We have to have discretion because every defendant is different, every situation is different. And if we didn't have that sort of discretion, then everybody would get treated the same, and they're just flat out not the same.
That's right. That if every DWI case had the same offer or the same punishment on it, it would be ignoring the fact that maybe this particular individual has done some fantastic things his or her whole life. And we would just be looking at this one moment in time where they're exercising a terrible judgment, and we might be comparing that person who has excelled in school or excelled in some particular gift that they've been given, and we would be comparing him or her to someone who really doesn't deserve a second chance, someone who has thumbed their nose at authority, who has fought with law enforcement, fought with their teachers, who has been a discipline problem for years, but they both have the same exact offense. We would not want those people treated exactly the same way. If that were the case, robots could do the job.
Right. Wouldn't need us. Just like I said, then you just follow the matrix. Check here. That's the sentence for this person.
Absolutely. And those kinds of decisions are best made, at least in my view, Stephanie, by prosecutors who are in touch with their community standard. By prosecutors who have experience, by prosecutors who know their judges, know what the parameters of the judges' philosophies are in some ways, and really knowing your community yourself.
Yes.
Not just the standard, but actually being a part of your community, asking questions when you have an opportunity at civic events or what have you. I think that prosecutors can make better recommendations, always filtering those decisions, I think, through this idea of securing the safety of the public at all times. Every decision that I make or recommendation that I'm making, it is being filtered through this idea of public safety. Do we need an ignition interlock? And then ultimately, what is just for the victim, what is just for the public, and what is just for the defendant?
Sure. We spend a whole lot of time concentrating on the defendant because that's the person in front of us. But you're right, that's almost third. We've got to look at public safety, we've got to look at victims, and then we come around to this particular defendant.
Absolutely.
And maybe it's not a level, maybe it's more of a circle, but they're all three important. And at different times we may focus on one, but they all play a part in our decision making.
Well, thank you for sharing your experience, and to the viewers, thank you for your time. We hope that this has been an educational experience. Thank you.